Good afternoon, good morning. Welcome everyone who has joined our webinar. My name is McKaylee O'Connor, and I'm a principal at NEPC. I also have the privilege of serving as head of DC Solutions and overseeing our thought leadership efforts. Today's session will take a closer look at several recent DC litigation cases and explore really what they mean for effectively managing your DC plan. We'll also discuss some recent developments at the DOL and what those changes could signal for future regulatory guidance. So with me today are two experts within the ERISA world, Ann Becker and Joe Adams, both partners at Winston and Strawn. I'm really excited to pick their brains about good governance practices today. So Ann and Joe, maybe could you start by telling us a little bit about your backgrounds, give us an overview of Winston and Strawn, the work that your firm does in this space, and then after that, I'll just mention a couple housekeeping items before we get into this session.
That sounds great. Thank you so much for having us today, McKaylee. We're excited to join you for this interesting and timely discussion. As you noted, my name is Ann Becker, and I'm a partner in the Employee Benefits and Executive Compensation Group at Winston. I'm dating myself a little bit, but for the last 20 or so years, my practice has focused primarily on the design and administration of tax-qualified retirement plans. And one of my favorite parts of what I do is to counsel clients and their fiduciary committees with respect to plan governance and plan investment matters. And so that ties in nicely with what we are going to talk about today. So, and I'm happy to share this with my partner, Joe Adams. And Joe, you go next.
Thanks very much, Ann. Yes, very excited to be here. My name is Joe Adams. I've been doing it maybe a little bit longer than Ann, a little aging myself even more. But I'm a partner here at Winston, co-chair of the Employee Benefits and Exec Comp Group, where we have about 35 wonderful people that do nothing but employee benefits, days, nights, and weekends. And like Ann, I spend a significant portion of my time helping some of our larger clients address fiduciary issues with respect to their plans. And so we're delighted to be here with McKaylee and looking forward to an active discussion. McKaylee, you want to give us the housekeeping notes?
Yes, let's do the housekeeping.
Yeah.
So, just a couple things. So this is a live webinar, so please submit any questions that arise over the course of our time today. We'll try to address them on the spot. We have left some time at the end as well. In order to do that, you go to the top of your screen, there's a box with a question mark. That's where you can submit questions. We're going to be monitoring those, so hopefully we get to them. If we don't get to them today, we will follow up with you afterwards and have a discussion. Materials, so Ann and Joe have some materials that they are going to reference. Those will be available after the webinar. They'll be sent with the recording, but they'll also be available on our website. And then lastly, we do aim to keep this webinar to less than 45 minutes. So everyone has some time before their next meeting or task, or if you want to go grab lunch. So we are not trying to take up your full hour. So with that, let's dive in. So, we are approaching the midpoint of the year. There has been no shortage of headline grabbing developments to keep everyone on their toes. But for today, I'd really like to narrow in on the focus, really focus in on several key legal cases that DC plan sponsors should have on their radar, particularly those that have implications for plan governance. And so why don't we start with kind of the biggest one out there today, Cunningham versus Cornell University, focus on prohibited transaction. I think this case took many of us by surprise, but it does offer some really important lessons from a governance perspective that I think are worth unpacking. So let's start there. Joe, I'll hand it over to you, and then we can take it from there.
Terrific. Thanks, McKaylee. Yeah, you're right. This is a big case. Anytime we have a Supreme Court case, this is a big one. This is a particularly interesting one because there was a split among the circuits as to how they would address the these sorts of prohibited transaction claims. And just to take a step back, this case started as a kind of a classic record-keeping breach of fiduciary duty case, and where a lot of the ERISA litigation tends to be these days, that there's a breach of the duty of loyalty or the breach of the duty of prudence. But what had become increasingly common is to staple onto those sorts of complaints a claim that there's been a breach, there's been a prohibited transaction. So if you think about the duty of prudence and the duty of loyalty as being sort of the core fiduciary duties, you could probably get to prohibited transactions from that anyway, but prohibited transactions set forth in the code in ERISA are just things that Congress thought were particularly fraught and ripe for abuse. So there are transactions that are called out there. Anytime you have a transaction between a plan and a party in interest, and a party in interest is defined as the employer, it can be the union, it can be service providers to the plan. Anytime you have a contract between a plan and a party in interest, it could be viewed as a prohibited transaction. And there are separate prohibited transaction exemptions that make those things exempt because plans need to buy services. And so the one that's at issue in a lot of these cases is the exemption that allows a plan to buy services from a party in interest for reasonable compensation. And what had developed in the circuits, there was a very well noted case in the Ninth Circuit covering California and other states in the West, and AT&T, where there was alleged that all the plaintiff really had to do was say that there was a transaction between the plan and the parties in interest, and you didn't really have to allege much more than that. And the Second Circuit case had a better one from plan employers' perspective, plan fiduciaries' perspectives, that said you have to allege more than that. You can't just say, because everyone needs services from a plan. Every plan needs services from a service provider, so you need to allege more than that. And you had kind of these split among the circuits, and there's a couple cases in the middle that said maybe you have to allege, some sort of a conflict of interest or something that the fees were unreasonable. Like McKaylee said, there was hopes that the Supreme Court would adopt the standard that we needed to plead a little bit more than just saying there's a contract between the plan and a party in interest. But surprisingly, the court says, nope, that's all you have to prove, is that there's a contract between the plan and a party in interest, and actually a unanimous decision. So pretty much a slam dunk for plaintiffs, and kind of bad from the fiduciary perspective. And Ann will share some thoughts about where we go from here. But at a high level, how the Supreme Court views this is saying, well, it's the plaintiff's burden to allege the complaint. They have to, on the sort of the face of their document, they have to allege a complaint. And then if the defendants want to say, oh, but we're exempt because we qualify for an exemption, that's a different part of ERISA, and so the plaintiffs don't have to prove that, the defendants have to prove that. And the Supreme Court, I think there was some really interesting discussions in the decision. It's kind of a long decision, but Justice Sotomayor wrote the main opinion, and everyone thinks she wrote that because she's the only Supreme Court justice that actually was a trial judge. So she has some familiarity how you do these sorts of litigations, but some really insightful comments by Sotomayor, and also Justice Alito saying this is, it's really critical, because if these plaintiffs can survive a motion to dismiss at the outset, then they have so much leverage to take discovery. And a lot of our clients, people that are on the committees, are pretty important people in the company, and people that appointed the committees, our board of directors, and they might be CEOs or C-suite people at other public companies. So it gives plaintiffs an incredible amount of leverage to force a settlement on that. And Alito really said that you could feel like you're right on the merits, but you'll be forced to settle. So the Supreme Court tried to lay out and articulate some different ways in terms of how trial court justices could address that, and allowing sanctions if there's frivolous motions, allowing defendants a chance to plead quickly and try and keep the motion to dismiss moving. But I think we're kind of skeptical as to whether that will really work in real life. And I think we will likely see that this is not only, this will be, plaintiffs will see this is what you do to try and bulletproof your complaint against a motion to dismiss. If you already had, like Cornell case, a run-of-the-mill fee litigation case, you should just staple on a prohibited transaction complaint. We see the plaintiffs doing this a lot. Forfeiture litigation, expense, and prohibited transactions now all seem to get lumped together, and hoping to, the judge will throw up their hands and say, like, let's take some discovery. So unfortunately, not a good result from from plan sponsor, plan fiduciary perspective. But Anne, you were going to share some thoughts in terms of what our clients are doing now in response to this decision, or how you can try and protect yourself against this.
Great, Joe. Yes, unfortunately, the Cornell case is unlikely to stem the tide of litigation, as you said. So clients are asking, well, what can we do in light of this to mitigate risk? So we had, unfortunately, there's not a magic bullet or prescription to avoid being sued. But I think that this case really underscores how you can demonstrate prudence by using a good process. And so that'll be a theme probably of our discussion this afternoon. One of the ways is, it's many of our clients that have company stock funds. The deadline for the 11K filing is coming up at the end of this month. And then for those otherwise, plans will file a Form 5500 later this year. And as part of that, you'll have notes to the financial statements, the plan audit that describe the plan terms, and then otherwise in the filing we'll talk about fees and other details related to the plan. And so our first suggestion is to use that as an opportunity to review those notes to the financial statements and make sure they're accurate and up to date, reflect the current plan terms, and make sure that the plan administrators really understand the fees that are being described in those filings, because that is what plaintiffs' attorneys use when they're scoping out potential targets for these lawsuits. Another thing to think about is when was the last time that the plan did a request for proposal, or RFP, for record keeping and other services provided to the plans? I think what as Joe mentioned, the prohibited transaction alleges a contract between the plan and a party in interest, and the defense is that reasonable fees were paid for necessary services. And so we anticipate that there might be that might put a little more pressure on RFPs, and so that plans can have that external validation that of sort of what's out there in the market, that they are paying reasonable fees for the services being rendered to the plans. So we might see an uptick in requests for proposals related to major plan services like record keeping and investment consulting and the like. And then finally, if the litigation just becomes too much, some plan sponsors may decide to pay the fees themselves. And this could be an expensive proposition for some plans, but some other plan sponsors may determine that the risk mitigation is worth it, especially if risk mitigation benefits everyone, but it can also result in less expensive fiduciary insurance premiums. So that may be, depending on what we see coming out, we may see more plan sponsors willing to take over that responsibility. But I don't know, Michaeli, what you see sort of in your book of business in terms of how different plans approach these issues.
Yeah. So I would say, from a record keeping RFP perspective, we recommend that clients go out to bid every 3 to 5 years. We also, as part of our annual plan fee and trends survey, kind of are looking at how your administrative fees, as well as investment management fees, compare to kind of the marketplace. And that helps us, support doing an RFP either sooner or later within that 3 to 5 year window. Definitely a very good practice. The market changes significantly, over time. And so even if you're happy with your provider, there are always opportunities to either reduce costs or enhance services. The second part about, having the plan sponsor pay administrative fees is really interesting. I was looking at some of our data from our latest annual plan trends and fee survey, and about 18% of plan sponsors are actually paying their plan administrative fees today. So it's not the majority, but it's definitely not a small a number of plan sponsors, close to 20%. And your comment about, reducing fiduciary insurance costs, I think is really important and interesting. Do you anticipate that these costs are going to increase given some of the recent litigation, particularly this, Cunningham versus Cornell case? Are you starting to see increases in insurance costs, or do you think that may happen later on this year?
I don't know, Ian, if you have thoughts, but I think it's a little too soon for that. I mean, the cost has definitely been going up significantly over the last few years. I don't know if people have, if we've seen enough experience since the Cunningham case, Michaela, to know for certain, but I think it will go up, and we've had pretty interesting discussion with some of our clients. I'm sure you have as well, in terms of all the things the insurers now ask for when they, because it's almost like the reverse of the plaintiff litigation, because they'll say, have you ever been, trolled on Facebook? Do you have company stock? Do you have an independent fiduciary? It's like, it's all the things when they're assessing your premium. So I think your point's a good one, that if companies are closed, and, depending on what the record keeping fees are, if you made that change to pay the record keeping fees from the company rather than plan assets, then I think definitely you go to the fiduciary insurer and say, here's the things we've done to, reduce our risk profile, and we think we should get a reduction in our premium. I know clients have done that, so I think it's something that might be worth exploring based on. And as the record keeper fees have trended down too, it's a little easier to maybe think about doing that. It's, we don't want to be cavalier throwing around people's money, but it might be a pretty good risk trade-off there, because that would at least take one of the plaintiff's favorite tricks out of their toolkit.
Right. Well, great. So I want to pivot a little bit. Earlier this year, American Airlines was sued for breach of fiduciary duty. There was also some kind of ESG related claims. In addition, at the end of 2024, we saw a United Health Group settle a fiduciary breach lawsuit that had been pending since, I think, 2021. Now, the American Airlines case is still unfolding, but what insights can we draw from these developments to fiduciary, breach cases? How can plan sponsors really strengthen their governance practices in response to what we learned from these? And maybe I'll hand this over to you, Anne.
Sure. Thanks, Michaela. I'll start with your first question. And I think that these cases remind us that when an individual serves in multiple roles, so for example, in a settlor capacity as a member of the finance department of the company, and then in a fiduciary capacity as a member of, say, the plan's investment committee, that when someone has more than one role, they have to be sure that they act in only one capacity at a time. And when they take an action, that they're very cognizant of whether they're taking that action as in their settlor capacity or in their fiduciary capacity as a member of the committee. And so these cases illustrate sort of what happens when the lines separating those settlor roles and fiduciary roles can get a little bit blurred. And so very briefly, in the American Airlines case, a federal district court in Texas held that American and the Benefits Committee breached their fiduciary duty of loyalty under ERISA because they allowed BlackRock, the investment manager for their passive investment fund suite, to engage in ESG-focused investing and proxy voting, contrary to what the court determined was in the best financial interests of plan participants. And BlackRock at the time was one of American's largest shareholders, as well as one of their largest corporate debt holders during the pandemic, when American was facing some business challenges. The Benefits Committee delegated oversight of BlackRock to an internal asset management group, as well as an external consultant. And I think key to this point, the internal group also managed American's corporate relationship with BlackRock. So the court found that the committee members were aware of BlackRock's ESG expectations and the potential consequences to American if it failed to meet those expectations. So, in finding that American breached its duty of loyalty, it's because the court determined that they failed to prevent their corporate interests from bleeding over into their fiduciary decision making, and that their failure to question BlackRock's ESG activities was due either to Americans' own corporate ESG commitments or a desire to appease BlackRock. Similarly, with respect to the United Health Group case, and in that case, the participants sued planned fiduciaries over the retention of some underperforming Wells Fargo target date funds. In denying defendants' motion for summary judgment, the court found that there was a genuine dispute of material fact as to whether the United Health CFO and others intervened in their to keep the Wells Fargo target date funds after the fiduciary committee initially decided to remove them. The allegations included a statement that the CFO allegedly directed what a balance of trade ledger, a look at the different proposed investment managers and sort of the scope of their business relationship with United Health, and then allegedly upon determining that Wells Fargo was a significant business partner, the decision to replace the Wells Fargo target date funds was reversed. And so we think that these cases illustrate how from time to time, the company and the plan may have competing interests. And so this is really just a reminder for those fiduciaries, listening in today, that the purpose of their actions and transactions as a planned fiduciary, really the primary purpose, the only purpose must be to benefit plan participants and beneficiaries. And just a reminder, you can't put the company's interests above those of plan participants. And with respect to your second question, the second part of your question, Michele, regarding how plans can strengthen their governance practices in light of these cases, I'm going to turn it over to Joe for some thoughts on committee composition and other questions to consider in light of these cases. So.
Perfect. And yes, I think there's been, like you said, there's been much intrigue over the American case and finding that they breached their duties, fiduciary duties, by investing in ESG funds when, in name at least, none of the funds actually were ESG funds. So it's kind of a head scratcher of a case, and we'll see how it actually plays out. But I've had discussions with several clients. Like you said, I think, like Ann mentioned, part of the thing that maybe is troubling the court and maybe is a takeaway for planned fiduciaries is American had that fund group that provided information to the committee and then also provided information to BlackRock as an investor. And I've had discussion with some clients, if you have investment relations people that might, and this gets tricky because some of these big firms, BlackRock and Fidelity and Vanguard, own significant portions of every company, right? So if you have a situation where you have one of those entities that's an investor in your company and also providing services to the plan, it might be a good opportunity to think about, do we have people on the committee or advising the committee that deal with that entity and both its role as an investor in the company and a service provider to the plan? And you might think about taking those people off the committee or at least having them recuse themselves from any decisions that involve that entity. Thinking about it, it's somewhat similar to the discussion a lot of our clients had if they had company stock in their 401k plan. Sometimes the CFO, the general counsel, other people have such significant information, and this is has gone to the Supreme Court multiple times about how they're supposed to sit on the horns of a dilemma here between not disclosing material non-public information and fulfilling their duties to the ERISA plan, their fiduciary duties, that a lot of times those people have just been taken off the committee. And so that was done over the past years. And I think this case might be a good chance to think about who are the right people on the committee and maybe take a fresh look at that. A lot of when we're doing public company exec comp work, it's kind of a requirement really that you look at the charter every year for the compensation committee of the public company board. A lot of our ERISA clients follow that same approach, and they review the charter every year, not necessarily looking for changes, but trying to think of best practices and ways we can tighten up and protect the committee. And so as part of this procedure for next year, you might want to be thinking and maybe working with the general counsel's office to think about, do we have the right people on the committee? Is it structured the right way? Separate and apart from that, do we have the right committee? The United Health case is its own, reminder of trying to keep everyone in their lanes. Like Ann said, we generally have, anytime we do a fiduciary training, we're always trying to tell people that ERISA envisions that the same executive at a company can have multiple roles. They can wear a settler hat and they can wear a fiduciary hat. They just have to know which hat they're wearing at any particular time. With that said, it's better to have them just be different committees entirely. I was talking to a client this morning, coincidentally, who said that's what we're going to do, is just separate the roles to make it clear and not do that. United Health case is, someone who's not even on the fiduciary committee, but then leaning on the fiduciary committee. And case law would make it clear that that person becomes a fiduciary too, right? There's a concept of functional fiduciary. So if you're forcing people to do it, and it just looks terrible, right? You can tell they just had to settle it, right? My favorite, this will be my new favorite case for fiduciary trainings. My favorite case prior to this was CEO of a large office supply company telling all of his direct reports, if anybody that's providing services to you isn't buying their paper from us, terminate them and move, and get somebody else. And thankfully, the CHRO had the good sense to call and say, hey, Joe, can I terminate XYZ large bank because they're not buying our paper from us? I'm like, obviously you can't do that, right? You're using the plan assets for, the benefit of the company rather than participants. So, it's a good reminder that everyone has to stay in their lanes. And we spend a lot of time setting up fiduciary structures to protect the committees and to protect the boards that appoint committees. And you got to make sure everyone stays in their lanes. And when they're wearing their fiduciary hat, they act in the best interest of participants. So I think we can move to the next. Yeah. Go ahead, Michaela. You have something to add?
Yeah. So just given time, let's talk a little bit about forfeitures. We actually had a webinar maybe 7 months ago on forfeiture cases, which, by the way, the replay is still available on our website. So we'll keep this a little bit more brief, but I do want to bring it up because it has been a topic within the litigation space, and I do think it directly ties to governance. Have there been any developments, I guess, maybe in the last 6 months, or should plan sponsors be mindful of kind of their processes as it relates to forfeitures? How does that impact their overall governance process? So maybe I'll give this back to you, Joe, and then we can go from there.
Absolutely, yeah. And we know you had a presentation recently, so we tried to summarize all this to 2 slides. And so the first slide kind of sets up the rule that the IRS, for years has said that it was permissible to use forfeitures to reduce the employer contributions, could also be used to reduce the expenses of the plan. But that's been the rule forever, and it's in virtually, until 2 years ago, it was in everyone's plan, and no one thought much about it. The IRS reaffirmed that rule and proposed regulations that were issued in 2023. And interesting to note, and maybe a good thing for people to note, is you really have to be using forfeitures within 12 months. So think about doing that. But anyway, IRS side of the house was pretty clear. Plaintiffs within the last few years have brought this allegation saying that, well, it would be better for me if you would use the forfeiture. And I'm being charged for the expenses, right? A, the expenses are too much, and you guys did a bad job being fiduciaries monitoring expenses. But B, it would have been better if you'd used the forfeitures to reduce those expenses rather than charging me for them. And again, notwithstanding, and so you breach your fiduciary duties, and it's anti-inurement. You're using those assets are going back to the company rather than for the benefit of participants. It's a privileged transaction. All these things are alleged, and the fiduciaries have said, hey, it's in our plan. The IRS has blessed this. This is a settlor function. We should be able to do this. And the short answer is, Michaela, has there been, I think we're up to about 60 cases at this point. And it is all over the map, unfortunately. The most recent case, I think, was against UBS, and it involves $45 million in forfeitures. And it's just something that seems to keep coming. Like I said, it seems to get stapled to any other claim. Now we have record keeping claims that get stapled to those. So there has been some favorable results, and if the some courts have said that have dismissed the complaints and said the claims are overbroad, and fiduciaries don't have an obligation to maximize participants' benefits. Other courts have struggled with the idea that if you told me all that stuff about you're a fiduciary, if you have discretion with respect to plan assets, if the plan document gives whoever's deciding what to do with the fiduciaries, with these forfeitures, the discretion whether to use them to reduce employer contributions or reduce expenses, then that's a fiduciary decision, and almost always would then favor giving them to participants. So lots of those claims have survived motions to dismiss. There's been a fair number of settlements out of those 60 or so cases. So it's sort of a mixed bag in terms of results. It doesn't seem like it's likely to be a prompt resolution. I think there's we'll talk about what might come in the new administration. I think the nominee for the DOL, EBSA, has some hopes of trying to solve it. But Anne, what are you telling folks we should do in the meantime till we get resolution on this?
Right, Joe. Well, since as you said, plan terms are often driving the resolution in these cases where there has been one. Our suggestion would be, if you haven't already, to review your plan terms regarding the use of forfeitures. And it's the company's decision in terms of how to fund employer contributions under the plan and how much to contribute toward plan expenses. But once that decision has been made, our suggestion is to amend the plan to specify the use of forfeiture so that it is not a choice left to a fiduciary under the terms of the plan. And it's been interesting as we've talked with clients about the use of forfeitures that it's come to pass too, as you mentioned, Michaeli, earlier, that the record-keeping marketplace is forever changing. One of the things that we're noticing is a lot of record keepers can pass through to plans float income. So float income is different from forfeitures. It cannot be used to reduce employer contributions, but it does, the discussion of forfeitures and how to use them has also, I think, brought into other types of unallocated amounts, and how the plan fiduciary's duty to think about how to use that float for to the best interest of plan participants, which could be to pay plan expenses, or could be to reallocate to other plan participants. But I think there's certainly the forfeiture cases and those, but it's also it could be a broader discussion, just to, again, a housekeeping item to understand amounts coming into the plan and how they're used. So,
yeah, to kind of add to that, Anne. So I think we've been having a lot more float conversations lately. Some record keepers have changed their approaches there. You see kind of a variety of ways that record keepers either reimburse or retain float. But just given how high interest rates have been, float revenue or interest has actually been quite large. And so you have a significant amount of money if some of that is actually going back to the plan. And to your point, having a process in place to ensure that that is being either reimbursed or used to pay plan expenses, so that it's not sitting there and accumulating over time, is a good practice.
exactly.
So I know we want to stick to our timeline to give people some time before their next meeting. So I want to talk a little bit about the DOL. So Daniel Aronowitz has been nominated by President Trump to head EBSA, the Employee Benefits Security Administration. His confirmation, right, is still pending in the Senate. But there's been a lot of hype or kind of noise about his appointment and what he could potentially do for the Department of Labor. What are you thinking? What should we expect from the DOL in terms of fiduciary, supporting fiduciary responsibilities? Are we going to see kind of an increase in guidance, decrease in guidance? I know you'd kind of mentioned a little bit in terms of wanting to reduce the number of frivolous litigation. Is there that really potential here? We've had some removal of cryptocurrency guidance back in May. So very interesting to kind of get your thoughts of where we may see the DOL going, any broader policy shifts that we should expect.
Sure.
Yeah, go ahead, Anne.
Oh, sure. I think in his public statements, Mr. Aronowitz, as you said, Michaela, I think he's kind of had three goals, and one of which was to improve enforcement by making it more even-handed and more efficient. I think he's trying to shorten the length of time of some of these investigations. He also wants to provide regulatory clarity and reduce the frivolous lawsuits, as you mentioned. And then his third goal is to encourage the expansion of employer-provided retirement and health and welfare plan benefits, including, I think, he mentioned support for ESOPs. So among the issues that he thought needed more clarity and stability are some of the issues we've already discussed today, including, ESG factors and plan forfeitures. So I think he's eyeing those. But he also noted issues such as modernizing DC plans to include alternative investments like private equity and cryptocurrency, and then addressing the extent to which the fiduciary rule applies to rollovers. So we've listed here just a couple of areas, even though Mr. Aronowitz's confirmation is still in process. The DOL is already moving toward some of the initiatives that he has described. The first of which I think was to unwind the Biden era cryptocurrency guidance, and that is in 2002, the DOL directed plan fiduciaries to exercise extreme care before offering cryptocurrency investments in 401k plans. And this got some attention for a couple of reasons. One, which was that it was calling out one type of asset, and the other was that this extreme care extended to brokerage windows as well as the core investment lineup under the plan. So upon the Trump administration, upon the initiative of the Trump administration, the DOL rescinded that 2002 guidance in favor of what they're describing as a neutral stance, where plan fiduciaries would consider the relevant facts and circumstances, but leave open the possibility of the inclusion of all various asset classes. And then separately, in the course of litigation in the Fifth Circuit Court of Appeals, the Trump administration indicated that they would rethink and initiate new rulemaking with respect to the ESG rule previously passed by the Biden administration, which provided that plans could consider the economic effect of ESG factors, but didn't have to when determining making a choice as to which investment options to include in the plan or how to vote proxies. So these are a couple of the early signals that we've gotten towards those areas, but I think it remains to be seen. Joe, I don't know if you've heard of more or different or other areas to watch as we see what the new administration has in store.
No, I think that's I think we think it's kind of a mixed bag because he has a background as an independent fiduciary previously. He is, there's some parts of that we really like that I think our plan clients and some of the advocacy groups are favorable to, particularly like you said, limiting the audits, right? We've had so many clients have extended audits regarding missing participants that just drag down and turn out to be an incredible expense and resources. So that would be great, someone who's sympathetic to that. And I think the crypto thing, while it was probably well-intentioned, was kind of hard to defend in terms of creating a new standard of extreme caution that didn't really exist in the statute. And like you said, extending into the brokerage window really was a troubling thing. So I think it's good that those two things are solved. I think a lot of our clients are, not, and I certainly welcome your thoughts, Michaela, in terms of what you're seeing. Our clients have not expressed a ton of interest in cryptocurrency, even in their large defined benefit plans, where I think they have alternate assets and all kinds of other things going on, hedge funds or whatever. So I haven't seen even the real slightest uptake of interest in crypto, even if financial planning would say it's gotten to the point where it could be 3% of a portfolio, a huge portfolio. It's just do participants in a DC plan really have the knowledge to do that, or as much as it's kind of catchy to have the democratization of private equity funds too. That may not be exactly right for a lot of participants in a 401k plan, particularly if something they can invest in directly. It might make sense again if you had a custom target date fund to put a little allocation to each of those things where the participants didn't really have to know all the inner makings of the sausage there. But we'll see. I mean, I'm a little worried that some will get that so many of those industries are so excited about the change in administration will get guidance that sort of steers too much there. So we do sort of seem to have these ebbs and flows between ESG's all in, now it's out, crypto's out, now it's all in. So it's a challenging road for fiduciaries to navigate that. And again, goes to some of Ann's earlier great points about having a good record of what we considered and documenting what we've considered. So if it is challenged later, we can document that we went through a prudent process in coming to our conclusion. I don't know, Kaylee, what are you seeing? I mean, are you seeing interest in these things with your clients?
Yeah, no, I mean, I think, the kind of common theme across ESG and crypto and privates is, there's just ping pong guidance from the administrations. And anytime you have guidance that changes every 4 years, it creates inaction in the plan sponsor community. And so, you don't want to go down a path and go through all your due diligence and research to add something that will be a target on your back in 4 years, right? And so I think we'll see some small adoption kind of in the private space. Cryptocurrency really has not come up. We've had a couple inquiries regarding kind of inclusion. The themes within the investment menu structure space is, continuing to streamline and reduce the number of options in an investment menu because so many of the assets are going into target date funds that the core menu is really not gaining much assets. And so the question is, where would a cryptocurrency type kind of exposure go? Maybe in professional management, maybe in the self-directed brokerage window. But is it really a key asset allocation building block? No, not at this point. Doesn't mean that this may not change in the future as our, financial system evolves over time. But at this day and age, we're really not seeing a lot of uptick in the cryptocurrency space. When it comes to private markets, that's been kind of the new hype, right? We've been talking about retirement income for so many years, and finally something new to talk about across DC plans is the democratization of private assets. Granted, we've had a number of clients using private real estate for many years, particularly within their target date fund strategies, but private equity is a newer kind of topic. And, we're currently kind of unpacking a lot of what it means to add private equity to a DC plan. I do think, in theory, there are benefits, but the implementation and execution, there are some really high hurdles there that need to kind of be understood. And so again, kind of going back to your comments, process, due diligence, thoughtful kind of consideration is what's going to be important for plan sponsors as they evaluate some of these newer items and whether they're really going to improve participant outcomes. So I think maybe the only other area that we really haven't touched on today is managed accounts. And, from a process perspective, and I'd love to get your thoughts in terms of, what you're seeing across your clients, but I know across our clients, we have increased the number of managed account reviews in the last 5 years. So really helping clients understand what it is that they offer, what are the fees, what are the engagement levels, what is the real value add of managed accounts, and making sure that fiduciaries are going through that process to really document and just like they would any other investment option within the plan. So maybe I'll pause there. Has that kind of been what you're seeing or recommending across your clients as well?
It is. Anne, do you want to speak to it?
Sure. I just think that, just like you said, Michaela, I think it's really important that plan fiduciaries understand the services that are being provided to plan participants and the fees that they're being charged for them, and to understand how participants are using those managed account services, and if they're using it in a constructive way, just like they would any other plan feature. So I think that goes to exactly like you said, the process point, and the documentation, the good documentation makes sense in this area as any other. Joe, I don't know if you have anything else
Yeah, I
you'd like
think
to add.
I totally agree. I think it's a tough one because it's you're exactly right, Michaela. You'd be well served for fiduciaries to look at this because it does seem like it has potential for litigation because there's not a lot. It's not easy to switch to a different provider, right? Most of these record keepers kind of have their provider you have to use, and it's either take it or leave it, right? And so that can cause a real problem with the managed account feature. And the fees can be pretty significant on some of those. So I think, yeah, looking at how like you said, doing an analysis of how different is this in terms of if Anne had just invested in a target date fund, she paid X percent for this, and then she could have gotten the target date fund for significantly less. There could be some, as a fiduciary, you want to be able to say we did that analysis and we think it works well for the following reasons.
Yeah. Yeah. So I know we are, oh, go ahead.
No, go ahead, Michaela.
Okay. We've had a couple questions come in, but I know we are at time. So I think what we're going to do, we did answer some of them throughout our comments. So hopefully we were able to address some of these. But what I think we're going to do is we're going to close out just to give people time before the end of the hour. We will follow up with you for those who submitted questions that we didn't get to. And I just want to say thank you so much, Anne and Joe, for your time today. We got through a lot in a very little amount of time, and really appreciate your comments. Also, the really actionable kind of takeaways and ideas for plan sponsors to kind of take back to their companies and their committees to review their own governance practices. So thank you. And thank you to our audience for tuning in, for asking questions. We will, again, send the replay and the materials out to you very shortly, and we hope to see you on a future webinar. Thank you all very much. Have a good one.
Thank you,
Thanks so
Michaela.
much.
Thanks, everyone. Bye now.